Okay, everyone, we'll get started. Welcome to this breakout session on solicitation under the marketing rule. Out of the 12 breakout sessions at this conference, this is the most crowded, so glad you're here. I'd like to introduce our panelists, just going down the line here. First, we have Gordon Eng. Gordon is General Counsel and Chief Compliance Officer at Sky Harbor Capital Management in Greenwich, Connecticut. He has more than 30 years of financial and legal experience and was of great assistance to the IAA when we were developing our comments on the marketing rule when it was proposed. Next, we have Dan Bernstein, who's Chief Regulatory Counsel at Market Counsel, which is a compliance business and regulatory consulting firm for investment advisory firms located in New Jersey. He's also an attorney with the Hamburger Law Firm, and Dan has a wealth of experience with providing legal services in the securities industry. And finally, we have Mark Perlow, who's a partner at Deckert in the San Francisco office, representing investment advisors, mutual funds, independent directors, hedge funds, and broker-dealers on a wide range of regulatory and transactional matters. He previously worked in the SEC's Office of the General Counsel and the Division of Enforcement, and you've most likely heard Mark speak at one of our IA events. He's a go-to speaker for us. So I'll give the first code word nice and early. It's explore, E-X-P-L-O-R-E, explore. So we all just heard the general session on implementing the marketing rule. And now this session is dedicated just to discussing the solicitation aspects, although I guess we have to get used to not calling it solicitation anymore. So I'm going to ask Mark to start and lay the groundwork for us. Over to you, Mark.
Thank you, Laura, and thank you for reading the note that my mother sent to you before the event. So I'm sure you've all spent as much time as we all have reading the marketing rule release. And like me, the first time it probably wasn't intuitive because the SEC tried to do a bunch of things that weren't there in the original regulatory scheme. But at a high level, the new solicitation regime, which is now classified under the defined regulatory term of endorsements, is much like the rest of the marketing rule. What the SEC tried to do was broaden the scope of the rule, but at the same time make it a little bit more flexible and principles-based. And as with so much else in the marketing rule, both of these tendencies have resulted in interpretive difficulties and practical difficulties we'll discuss today. But at the highest level, the SEC combined the old cash solicitation rule and regime together with testimonials and other types of endorsements into a single set of rules. And the people who provide these things, endorsements or testimonials, now have this new regulatory term of art called a promoter. Although I think most of us will still probably fall into the old language of solicitors because that's just the way we've thought about it for years. The rule now covers non-cash compensation. That's one way in which the SEC has expanded the rule. It now also covers private funds. The SEC rescinded the old no-action letter that excluded private fund managers from the scope of the old solicitation rule. So in its essence, at a high level, the rule is intended to focus the regime on three primary regulatory goals. One is disclosure of compensation that creates conflicts of interest, as well as disclosure of the conflict of interest. Second, oversight of promoters. And third, the exclusion of bad actors. And the SEC has tried to, by broadening it all and creating principles, make it a more flexible and streamlined regime. You be the judge when this panel is done. Can we go to the next slide? Because this chart, which is on the IA website for members, sort of captures to me how complicated this seemingly simple regulatory goal and regime is when you actually dig beneath the surface. On the top are sort of the 5 regulatory requirements of the rule that represent a sort of menu that the regulator applied to different scenarios. So the basic element is a required disclosure, and in most cases that's going to be a required disclosure of the terms of the compensation you're paying the endorser and related conflicts of interest, a written agreement under which that compensation would need to be paid. Then there's the oversight piece of the rule. You need to have a reasonable basis for believing that the endorsement and the endorser is complying with the terms of the rule. Third, there are disqualification provisions, which are more complex than we will have time to go into today, and we'll just use the standard term people use in the literature, which is bad actor. And finally, there's a reminder that all of the general prohibitions that apply across the marketing rule apply here too. Statements have to be true, they have to have a reasonable basis for believing them and have support if and when the SEC comes in, and they have to present benefits and risks fairly and balanced. So if you look on the left-hand side of this chart, you see the different scenarios to which the SEC applies this regulatory menu, such as it is. The base case is the top one. You are compensating above a de minimis threshold an endorser. You have to comply with all of these provisions. If you fall below a de minimis compensation threshold, or you don't provide any compensation at all, the written agreement and disqualification or bad actor provisions don't apply. Carrying over a basic principle from the cash solicitation rule, there are lesser requirements if your personnel are affiliated and they're clearly disclosed as such. In that case, the disclosure requirements are minimal and there's no requirement for a written agreement. Broker-dealers have a streamlined regime because they're already subject to regulation best interest, but you still need to have a reasonable basis and written agreement in place. And there are different bad actor rules if you're conducting a private placement under Reg D, which we'll discuss in a little bit. So there will be a quiz when this is all done. This is a multiple choice test. I've been reading the rule for over a year now, and I still go back to charts like this to figure it out, so you could be forgiven.
I just want to mention here that the IA does have other resources to help you understand this and implement this. We have a dedicated webpage for marketing rule resources where we kind of curate the law firm outlines and materials that we think are really helpful. We also include some of our own FAQs. We have links to our webinars that we've done on the rule. And those of you who are IA members, I hope you're already a part of our marketing implementation group. If you're not, feel free to join, because we hold approximately monthly calls and we talk about practical issues. It's a great way to talk to peers and hear from guest speakers like Mark and get your questions answered. So let's move on and talk a little bit about, there are definitely challenges in implementing the rule, but I think there will also be some really improved, great aspects to it. So Dan, let me turn to you. What are you looking forward to under the new rule as far as solicitation?
Yeah, thanks, Laura. So much like the SEC starts off with a disclosure, mine is a disclaimer. Mine's not a disclaimer, but I always think it's good to come up with where somebody's perspective is coming from. So I represent primarily small to mid-sized investment advisors, separate account managers, not a lot of fund managers. So most of our clients, the way that they're getting involved in this, to traditionally got involved, is they have a third party looking to refer business, and they say, hey, we want a piece of that. So is our core cash solicitation rule. We fit under the agreement. We had a disclosure, et cetera. So it's pretty straightforward. And I think this rule, if anything, has made it a little easier, a little more straightforward. It's taken out some of the redundancies, added some permissions. I wanted a few more things added, but you can't get everything you want, right? So on the whole, I give it a thumbs up. So the new rule is written a little bit more like an Advisors Act rule, a little more principles-based, a little less you have to do X, you have to do Y, and that's the whole new marketing, advertising, solicitation, endorser, whatever we're calling it, rule is a little bit more like the rest of the Advisors Act. On the whole, the solicitor replacement is maybe more practical for the advisor, the solicitor, and the client. I think if you look at all three of those parties, we are slightly better off, if anything, than we were before. So what are the differences? What is that flexibility? Well, the old cash solicitation rule required the solicitor to give the advisor's Form ADV to the prospect. I won't name names, but I'm pretty sure there were a ton of advisors that were not having the solicitor do that. Probably didn't even tell him to do it, probably didn't even get him the ADVs, and if they did, I don't think a lot of the solicitors were doing it either. I just don't think that was being particularly complied with. Because the advisor was then giving out that Form ADV. So the rule did acknowledge that there was some redundancies there, and now the advisor is the one to give out that ADV, and the solicitor, the endorser, the promoter, no longer need to give that ADV. So that's kind of a net benefit there. There was reasons why that's also helpful. If the solicitor gives out that ADV and the prospect reads it and says, well, what does this conflict mean? It's just not, doesn't help anybody. The solicitor can't answer that. Now, interestingly, we certainly need a disclosure coming from the solicitor to the client about the conflicts of interest and the existence of the fees that they're getting, cash or non-cash, but they no longer, the prospect no longer signs off on that acknowledgement, which was a big piece of the cash solicitation rule. I will say that I think a lot of advisors that I'm speaking to right now are saying, really didn't bother us before, and in our current relationships with accounting firms, with law firms, with other third parties that we deal with, we're going to continue to require that. Because the advisor, as Mark went over, still needs to be able to show that they're doing due diligence to ensure that those disclosures are going out. And it's a pretty good way to know that the disclosure went out if the client signed off on it. But it gives you that flexibility, going back to that principles-based rule. I, as an advisor, may decide to do that, but I don't have to do it. It also allows the firm to skip the agreements in certain circumstances, as Mark went over, including a de minimis payment, $1,000, I think it's annually. So it is pretty darn de minimis. In fact, we had a lot of firms that in the past have come to us and said, well, we want to compensate clients for referring other clients, friends and family. And did that fall under the cash solicitation? It depended upon whether it was cash. Now I think that clearly falls within this new solicitor rule. If it's going to be less than $1,000, we don't need an agreement in place, but that's not a big number. If you're offsetting fees, it might be a lot more than $1,000 in fees if you took on a couple $1 million
That's an hour of Mark's time,
Exactly.
or half an hour of
Half
Mark's
an hour.
time.
Half an hour. He bills in half-hour increments too. No. So there's no question that it gave us more ability, the de minimis, but I'm not sure that de minimis was as high as I had wanted it to be. One of the things Mark mentioned before is the disqualifications, and the disqualifications are not in place if it's a de minimis amount. But again, back to our principles-based, or do be careful. You should do some due diligence on who is referring you business and whether you still want to get in some type of relationship with them. So you may not have to stop them from receiving these fees, this compensation, but I do think it's something that's wise to continue to look into that to decide who you want to be doing business with. And I think I'm going a little long, so I'm going to just hit a couple challenges really quickly. The disclosure is now more encompassing than we used to interpret. Doesn't mean that it's more encompassing than maybe what the SEC thought, but we used to see those acknowledgments, those certifications from prospects saying, I'm aware that this person is getting a percentage of the fees. Now it's pretty specific that you need to show, I am getting 20% of your advisory fees for a period of 2 years and then 10% thereafter, something to that effect. So challenge will be there will now need to be more specific disclosure. I do want to quickly mention, and then I can hit on some of my other stuff later. Keep in mind there are still state issues. It was something I hoped I don't even know if the SEC would have had the jurisdiction for it, but one of the concerns amongst a lot of firms that are sending business to advisors is, if I get this fee, does that make me an investment advisor? And that, typically they don't have assets under management, they don't have clients in the requisite number of states where they'd be SEC registered, so it becomes a state-by-state look for them. And there are a number of states that say referral to an advisor and receipt of compensation, that's an advisory business. So I was hoping maybe we'd get some de minimis help there, but that didn't come, and honestly, I don't even know if the SEC could have done it. So don't forget that. It may not be your responsibility even as the SEC advisor of what that solicitor has to do, but it's going to come up, and it's still a concern. So I'll cede some time because I think I overspoke.
Gordon, would you like to chime in here?
Yeah, I act as a general counsel and the chief compliance officer for Sky Harbor. We're a boutique high-yield bond, corporate bond fund with half our assets are in a Luxembourg UCITS fund, which is a European mutual fund. And, you know, wearing a legal hat and a compliance hat at the same time actually, in some ways, comes in handy with this rule, for which I have really kind of mixed feelings on in terms of actually implementing it from the user perspective. You know, when they come out and say it's principles-based, you know, like when you're thinking accounting and IFRS, you think, oh, that means a little more flexibility. But the problem with a principles-based rule is that it's basically grounds for coming after you 5 years from now in hindsight. And there's no clear boundaries. So this particular rule is, I think it's going to take a lot of time and a lot of conversation between business, legal, and compliance. Because because of the lack of a hard line, there's going to be a lot of debate about what kind of cash or non-cash, particularly non-cash compensation is going to trigger a conflict of interest that becomes defensible or non-defensible, and then you have to be able to document that and expect that you may not hear anything with a FAQ or anything else until the first enforcement action comes 5 years from now. And I think this is a real problem with a principle-based regime because of this lack of a clear line and so many of the interpretive issues that this raises with how to implement something and how far do we go down the chain of non-cash compensation, and to what extent we can make an argument that, well, yes, you could make an argument that there's some prime broker compensation for increased volume, for instance, but does that really have a conflict of interest that's material? So I don't know. I mean, you're going to have to debate that in terms of the size of the company, the number of people you have, the service providers that you're involved with, and you have to contact all these service people. It's not only internal, but external communications until everybody's on the same page, because enforcement will come. There will be blood, and we don't know where it's going to come from right now. So it's not a gift here. It's real mixed feelings about it. And you know, the big thing, of course, just is that the Mayor Brown no action letter is rescinded, will be rescinded. So a lot of us depended on you know, third-party marketing of investors in private funds and saying, okay, we don't have to worry about that. Well, now you do. This is the same thing that you have to do with your SMAs. So, you know, as Dan said, maybe for your existing solicitor agreements, maybe that you only have to tweak those. But now you're going to have to come up with a whole new set for anybody if you have a private fund. And I think many people do have private funds. We have a private fund as well. We sub-advise a 40 Act fund, and then we have our UCITS fund. So I have mixed feelings about this principles-based regime because of the lack of clear guidance. And I do believe it's going to require a lot of debate and a lot of collaboration with compliance, legal, and your external service providers. So, and then we could talk a little bit more about what forms of non-cash compensation could be problematic.
And I think we got the message in the general session that we shouldn't hold our breath waiting for SEC staff guidance on this rule.
There is a theory of regulators. The reason why they like principles-based is because if you don't know where the line is, most people, especially if you're a lawyer, and probably most compliance officers, if you don't know where the line is, you're going to try to say, well, wherever it is, I'm going to stay far away from it as possible. So the thinking is that psychologically it actually results in better behavior, because the absence of a bright line means that you don't know where you can find the wiggle room. So everyone's going to try to be more conservative. So my inclination is that most people, as a first instance, will not take advantage of testimonials and endorsements, because when you actually read the rule and the 7 prohibitions and the interpretation that goes into it, why are you going to be the first one to come out with a TV ad or something like that, or have Matt Damon start talking to you? about why you should invest in something like this, and he's not an employee, so he's going to hand out all the disclosures and tell you how much he's making on this commercial. I would think that most firms are going to say, okay, thank you very much. I am not going to start doing testimonials and endorsements. That's my reaction on the practitioner side.
Mark, did you want to chime in on thumbs up, thumbs down feelings about the rule before we move on?
I share Gordon's point of view. It's a mixed bag. I would just add we do have a standard set of tools for dealing with the ambiguities that come with principles-based rules, and they are documentation, documentation, documentation. Think about the underlying reasoning and the underlying facts that justify your position and document them. So I think this is the tool set we're going to keep coming back to today, and I think you're going to keep coming back to for the next several years.
It is the hallmark of the Advisors Act to be principles-based. So.
Can I just add one more thing from a legal perspective, is that there's always a question. For example, the release said that the FINRA's 2210 rule, it's okay if you're a dual registrant or if you're under FINRA, but it's not good enough for this rule, so be careful. Now, why do they come out with that? I was thinking more about that. The reason I think the SEC has gone through all this is after best interest and this concept of what's the difference between the duty of the broker-dealer and the duty of an investment advisor. And as the new head of investment management quoted Judge Cardozo's, the punctilio of an honor most sacred. The idea is that as investment advisors, we have a fiduciary duty, and a broker-dealer doesn't, right, in theory. So 2210, the phrase that says that this may not be representative, of a testimonial, is not good enough because it's not good enough for the punctilio of honor most sacred, So if your business people ask you, is this good enough? You're going to reply, well, it's the honor most sacred. It's a punctilio of the honor most sacred. I don't know if it's good enough or not. So, this whole idea that we're a fiduciary as an investment advisor, the SEC has raised the bar. And that's why certain things that are acceptable from what you would think, since a broker-dealer, which is transactional, can get away with, you can't do that according to the SEC because we're held to a higher standard. And that's what you're seeing through all this. So that's why I'm also concerned about the enforcement that's going to come out of this, because they're going to hold us to a fiduciary standard when they go through the 7 prohibitions. And so that's why I'm concerned about it.
Well, let's move on and talk about one of the most significant changes to the rule, which is that it will extend to non-cash as well as cash compensation. And Gordon, we'll stick with you. How does this affect us in the solicitation aspects?
Okay, well, cash is pretty simple, and I think maybe Mark has some insight into why just cash was good enough, and the kind of can of worms that non-cash compensation opens up. But just before I turn that over to you for your thoughts on that, Mark, is that non-cash compensation, what is that? So if you have a discount on your fees for private fund, if you have any kind of any kind of volume discounts, anything like that, or if you get payment for brokerage or anything like that, all this stuff comes in. If you use other in our UCITS fund in Europe, we have a distributed model, so we use other broker dealers and other banks to market, and in return they have retrocessions, and so that all comes into play now if they don't exclude foreign-based funds, which is another topic. But another thing is that it would be an FCPA violation, but even apart from that, if you hire somebody as a result of, and it looks like you're hiring people in your company in return for referrals that you're getting from someone, that would be non-cash compensation. So there's any number of things that you'd have to go over. And so I would say that you'd have to go through every single plan, scheme, device, whatever you want to call it, that you've used to incentivize anyone to bring business to the firm, and then examine that and consider whether or not that would be non-cash compensation. Mark, do you have any?
Sure. So I point out that in at least 3 important ways, the SEC expanded the scope of what counts as compensation that makes you an endorser under this rule from what made you a solicitor under the old rule. First is the cash versus non-cash compensation vector, where non-cash compensation can even include a training session or gifts and entertainment. The SEC has made quite clear in the release. In that sense, they are following the FINRA rules. The second vector or expansion is direct versus indirect, where the SEC made clear that if you arrange to have an affiliate pay compensation or arrange to have your clients pay compensation, it's potentially indirect under the rule. And the third vector is, the third area of expansion is the rule doesn't say it's compensation if the advisor pays it. It says if the advisor provides the compensation. And I think it's a subtle but important difference. The example the SEC, I think, gives that illustrates this point is if you direct client brokerage, which of course is not your money, you're not paying, but if you direct it to a endorser in exchange for an endorsement, that's compensation for purposes of the endorsement rule. So just to illustrate the problems, some of the problems that come with non-cash compensation, I ran into an old friend and colleague from the SEC literally right before this panel, and reminded me, by the way, there are great things about coming to conferences you couldn't do by screens. And we were talking about the good old days of the SEC, which, as you know, if you ever sit around two SEC alums, the good old days of the SEC is whenever you and your friends were at the SEC. And this friend, reminded me that there was a reason why the old rule was the cash solicitation rule and not the non-cash solicitation rule. And that is that once you start defining relevant compensation to be non-cash, it scopes in a whole set of conduct that is where it's impossible to draw lines. Is a bottle of wine, if it's expensive enough, is that compensation? If you scratch each other's backs and endorse each other, is that non-cash compensation? You can go down this rabbit hole forever. And he reminded me that the reason why the old rule drew the line at cash was because it's hard to draw a connection between the relevant conflict and this non-cash compensation. But I keep that principle in mind as we go through and think about what really counts as non-cash compensation. Unfortunately, the rule is now what it is, and we're going to find ourselves in some interpretive situations that we wouldn't have before. But just, to continue on Gordon's point, I think discounted fee arrangements of some kind or another, or compensation that are provided as part of a larger relationship, now requires you to sit and think about whether or not you're somehow providing indirect compensation for an endorsement. So the example that comes up a lot is a wrap fee program, where, say, you're a sub-advisor. Of course, you are literally being introduced to the sponsor. The wrap fee program's sponsors' clients. If you direct client brokerage to the wrap fee sponsor, is that indirect compensation that you've provided? If you provide a discount to that advisor, and the advisor is the one that is paying your fees rather than the client, is that indirect compensation? I'm not meaning to suggest in all or most cases it is. What I'm suggesting is we have interpretive questions now, head scratchers that we're now going to have to dig in on. And this is where the point I made earlier comes into play. If you can document that discount is for a different reason, or if you can document that you're getting best execution, which you should be doing anyway, or that the commission rates that you're paying are the market rate, that's a reasonable argument to make. That's not indirect compensation. But where we draw lines here, of course, we're not going to get SEC guidance. We're all working through it together as an industry, and it's unfortunately not going to be as clear a situation as it was under the old rule for a while.
Just to follow up on that point, and the reason why you're going to need to get started on this right away is that, when you document, it's always what I tell my people is that there are no facts without evidence. And evidence usually takes the form of documentation, and you don't want to have it depend on a deposition testimony. But just a simple thing that what Mark said, that you document something. Well, what do you document? And if you don't want to document it so that it's conclusory. So in some ways, you have to come up with like what your company thinks will be the determining factors. Some kind of a decision tree based on materiality of the conflict, or something where you can actually say to an examiner, look, you may disagree with our evaluation materiality, but we did go through it. And we decided that there are 3 levels, 3 circles of conflict. And when something reaches beyond the 3rd circle of conflict, however we want to define that, we're saying that whatever argument you can make for indirect compensation is not going to be, we're going to consider that to be out of scope. And if you can show that there's some form of objectivity for it, and then you can document it, I think at least you're going to have a more credible defense rather than a conclusory statement that simply says, well, we just determined that that was not, in scope. You're going to, I believe you're going to probably need more than that. I don't know, Mark, do you feel differently?
No, I don't.
Yeah. Yeah. So, and that's going to be a tedious exercise, to come up with some kind of a rule-based, principles-based decision tree that shows how you determined that a particular non-cash compensation was out of scope. And just another quick point. Not all, even direct cash payments are not clear. And there was some guidance in footnote 163 and 164 of the Federal Register release where they talk about the importance of showing that there was quid pro quo. And the example they were used were platforms where the investor hires the platform provider or the search party to do a beauty contest. And if your firm is chosen, the firm pays the beauty contest platform. But because the intermediary was retained by the ultimate pension fund or the investor, that even though you, the chosen winner of the award, is making a cash payment, the SEC would not consider that to be payment for an endorsement or testimonial because there was no quid pro quo. And they mentioned that in the footnote 163, 164. And so that's another point, that even if there's a cash payment, if you can show there was no quid pro quo, that would be one of the things you'd want to have in your decision tree in the compliance manual about one of the first things that you'd want to say was there quid pro quo? And if you can document there was none, that I think that would go a long way to help on that.
Laura, do you mind if I just add
Yeah.
one quick thing? So I think we're all kind of learning this. I hear about the challenges, but what I like to kind of melt it down into some of its basics is, to me, a lot of these challenges are whether or not you would then have to go through an agreement in place and then that solicitor endorser providing the disclosure. But other than that, most of what I actually heard was something we'd probably want to disclose as a conflict anyway. So at least once a year, we tell people, you should sit down and just say, I should look at anything that I pay to someone else, either directly, indirectly, cash, non-cash, in order to garner some sort of favor. And then vice versa, what I get for making recommendations. Like, just come down to its base level and interpret where I have my conflicts that I should be disclosing to my clients. So I'm hoping that a lot of these won't be a surprise. It just might be that we have some more difficult things to get in place, because I agree. My example earlier of there's an accounting firm that wants to refer business to me, that's nice and easy. Some of that you've mentioned, it may be harder to put an agreement in place, and then really the challenge is that endorser handing out that disclosure. That's going to be weird. But I'm hoping that nobody's going to go, oh my God, I didn't even know we had these conflicts to disclose.
Count all the quids and count all the pros.
Yep.
Quids and the quos. I don't know how many people have been involved in an internal investigation in your firm, or indirectly or indirectly. I don't know if if you know this, but when you do internal investigations, which I did before in private practice, there's a warning that's issued to the witness called the Upjohn warning. It's called the corporate Miranda warning. And my feeling is that that's probably going to become the new marketing Upjohn rule, where every time an endorser or testimonial, that they should just give the Upjohn warning, which in an internal investigation, the first thing a lawyer does, the first words out of his or her mouth, if they're doing it properly, when talking to a witness for an internal investigation, is to tell them, I don't represent you, I represent the company. Everything you say can be disclosed, and the company owns the privilege. And we may even tell the SEC or other regulatory officials, whatever you say. Do you understand what I just told you? Yes, I understand that. And then usually it's documented in a write-up on the interview with the witness. And so usually, without having the witness actually sign it, that usually suffices in most cases to show that the upjohn warning was given. So I would suspect that if things go the way they are, which is that you're supposed to give the disclosure up front, that I think market practice will become that people will give a standard little marketing upjohn warning, which basically says, I'm a client or I'm not a client. I'm being compensated. There's a conflict of interest because I'm being paid for this. And I just want you to understand that before I go on with my pitch. And do you understand that? And you understand there is a conflict because I'm being paid. And the prospect will say, yes, okay. And then they go on with that. And I think and if they can if everyone starts doing that and everyone recognizes that this is just something that is required now, I don't think it'll be problematic. But I think it should become market practice, and that would be one way to take care of the immediate disclosure that's required for solicitors, is just to have a little stock phrase to let everybody know what your obligations are. So that's just drawing an analogy from internal investigations, and I think that probably should work so that you don't have to have a piece of paper to hand over to the prospect and have him sign it and go through all that, as long as that later on the call memo or the report that comes in from the solicitor said, we gave the marketing upjohn warning, the client acknowledged it, and then you go on with the rest of the report. That's what I would recommend and think that will eventually happen, depending on, again, there will be blood, depending on how much the SEC decides they want documentation and proof that those disclosures were given.
Thank you, Gordon. We need to move on to private funds. We are having a separate breakout session tomorrow dedicated to private funds, so I don't want to spend too much time on it now, but we just wanted to highlight a couple of important aspects as it relates to solicitation. So Gordon, just maybe a brief word.
Yeah, I think we've talked about that. Basically, there's no more Mayor Brown, so no action letter as of November 4th. So whatever extent you have solicitors selling on investors' prospects on your private funds, you're going to have to revisit that. Take a look at all your other arrangements where you have cash and non-cash compensation and discounts on your private funds. And don't forget that the usual precautions about whether you are required to register as a broker-dealer or an associate investment advisor when selling private funds, those rules have not gone away. So keep in mind that this is just one piece of it. You still have to remember whether or not your solicitation of private funds comply with the broker-dealer requirements.
And Mark, anything to add here?
So yeah, three I think, takeaways on how these rules apply to private funds. One is how the disclosure rules are going to work. Your placement agents are going to have to disclose their specific compensation. If they're broker-dealers, they're going to be subject to the Reg BI obligations. But you have a choice. Do you trust the placement agent to provide this disclosure themselves, or do you put it in your PPM and require the placement agent to provide the PPM at the time or close to the time of solicitation? Secondly, with all of your placement agents, you now have to comply with the oversight provisions of the rule. You have to have a reasonable basis for believing they're providing these disclosures and they're otherwise complying with the terms of the rule. You do have a standard set of tools you can rely on here: contractual provisions, periodic representations, questionnaires, due diligence, inquiries. And the SEC went so far as to suggest you could and should be asking your own investors to get their experience, although I think that's the far end of the compliance tool spectrum. And then finally, you have to have a reasonable basis for believing that your placement agent is complying with the bad actor provisions. So you have to do, if you're not doing it already, a little bit more due diligence on your placement agents. I think the main gift or the main give that the SEC gave the industry was they conceded in the release that annual inquiries should be enough. How much of a gift that is, we can argue with it. What I would hope and believe, though, of course, is that many placement agents, upon getting the bad actor inquiries and the due diligence inquiries, are going to prepare a standard set of responses for all of their own customers. It's going to be easier for them than responding on a one-off basis, and they are going to be getting these questions. So, Laura, back to you.
Okay, so let's switch over to social media. And, sorry. So Dan, can you give us maybe a couple of examples of how your clients are planning to use social media under the new rule?
Yeah, so when the new rule went into place, I probably had over a month, about 15 calls to discuss how everyone was going to start using social media. And yeah, they had marketing people come on about endorsements and testimonials. And since then, I think maybe one has gone forward with anything. So I think there's definitely some excitement. And I think what we usually see with investment advisors is a more measured approach, and it reminds me a little bit of some meme I saw where there's a penguin and like his buddy's walking with him, and then he leans over and the penguin hits him into the pool. And I think that's what we're going to see a little bit here is, as much as we have a lot of people that want to be first, we're going to wait for somebody else to be first and then poach some of what they're doing and see the SEC reaction. So I think it'll be baby steps, and this is, since the beginning of the use of social media, this is what we've told advisors, is you don't have to go all in, but it doesn't mean you have to be all out. You can take little areas. In the beginning, advisors wouldn't even have a LinkedIn page, they wouldn't have a Facebook page, they wouldn't let any of their staff use it in any way. And then they found, okay, we can use third parties, or we can find a way to have books and records, to supervise some. And they started to gradually start to use social media. And I think we'll see the same. I think we'll see the same here. Some of the easy stuff, like now being able to maybe have those endorsements on your Facebook page, as long as you're not going in and taking out the one that says, yeah, these guys suck. Right? So as long as you leave them all up there, I do think we're going to see advisors starting to utilize that more. But besides that, I think we're going to get a little wait and see.
Mark, there's a lot of disclosure challenges when it comes to social media. Clients will be coming to you.
So I would just point out that for most of my clients, the experience has been similar to Dan's and has been for some time. Social media has let other people figure that out first. But of course, there's a whole category of investment advisors for whom the internet ecosystem and the social media ecosystem is their primary ecosystem. Fintech firms, online investment or internet advisors, robo-advisors who've been dealing with the old cash solicitation rule, because there's an ecosystem of what we used to call solicitors are now endorsers, people who blog or who write review sites, and there's a whole set of market practices in which sometimes people are paid for positive reviews. And the good thing about the rule is you no longer have to ask those websites to deliver your ADV, which was never going to happen, or to provide the very specific disclosure statement you wrote for them. In addition, the rule has given us a little bit more flexibility in that it doesn't have to be the solicitor, the website that provides the relevant disclosures. The SEC gives the advisor the flexibility to provide that disclosure at roughly the same time as the solicitation. And of course, in the internet world, that's defined as when they click through. It's easier to establish that your disclosure comes at the same time as the solicitation that way. So one tool you could use is a landing page that provides the relevant disclosures when they come from a particular site. But all the problems have not gone away because, of course, you still have the oversight responsibility. You have to have a reasonable basis that they're complying with the rule, and in particular that their statements are fair and balanced. And I think there's going to be, if you're relying upon internet solicitors, a certain amount of monitoring their websites to see what they're saying, I think is going to matter. And to the extent that you are endorsing or entangling their statement or adopting or being entangled with their statements, either by helping to write it or by providing a link on your website to it, then you come into the whole set of considerations that Dan mentioned. And these were originally provided by the SEC in guidance back in 2014 on the use of testimonials in social media. And the bottom line principle is if you're going to curate content, don't do so in a way that favors the favorable statement and disfavors the unfavorable statements. You can use it sort of to police objectionable or offensive conduct, but anything that looks like you're manipulating it to make yourself look better or paying other people to do that is likely going to be seen by the SEC as not fair and balanced.
Mark, but would you agree, though, that a page, a Yelp page, for example, or a Robinhood page that basically has comments, but you have nothing to do with it, you don't hyperlink to it, that you'd be basically out of scope in those cases?
That's right. Somebody else's problem, right?
Right. And, but what about if somebody's like purposely putting in bad information about you, you know, like on one of these pages, and you feel like you're being defamed or something? I mean, do you have any defenses without being then accused of you know, adopting or entangling on something like that? What are the?
I think it depends. If you're paying the page,
No, you're not paying.
then you're entangled with it. I mean, it becomes much harder. But if you're not paying them and people are making false statements, I think it's reasonable for you to object to the people who have sponsored the website, if they are not, or the social media site, if they're not willing to take down content that you're able to demonstrate is false. It's maybe a little bit more risky for you to go onto the website and post your own comments. But I think if it's done in a fair and balanced way, and again, you're not paying the website, it's going to be defensible. If you do it in a way that it's not an advertisement, you don't link to it, you don't otherwise get entangled or pay. But you know, it is a little riskier, and we don't have guidance from.
I know we have to move on. I'm just going to throw one more out there. What I would tell people to not do, and I think this is kind of what you were getting at, Gordon, and like the entanglement, the adoption, is I wouldn't go to your best clients and say, please go on to, even if we didn't post to it, even if we didn't link to it, if you're incentivizing someone or asking your best clients, and not the bad ones, to go on to the Yelp or whatever page, you know, that could be problematic as well.
I would just say that if you become aware of a blog or anything else that has positive things about it, I would not hyperlink or anything like that, because those things can also turn negative, and now you're caught into it. So, you know, if it happens, you know, it happens, and you'd be aware of it. But I would, if it were me, I would just say, okay, I'm glad somebody's saying nice things about the firm and all that, but I would not advertise it, or I would not hyperlink it or mention it in anything else, because then, you know, we'd be attached to it if it turns negative. So I would just stay away from those things.
Okay, we just have a couple minutes left. The second code word for continuing education is ADEPT, A-D-E-P-T, ADEPT. So let's wrap up by talking about some of the most important steps to take to implement the new rule from a solicitation standpoint right now. I'm just going to go down the line and ask each of you to give a couple of implementation tips, starting with you, Gordon.
Yeah, well, they mentioned that at the general session. It's kind of common sense, right? And we talked about it today, but I think the first thing you want to do is sit down and make sure you read the rule, and then take a look at your compliance manual and start going through policies and procedures. There's a couple of things in the release that specifically say that if you have set forth policies and procedures, such as, you know, when it's okay to edit something and not become entangled or adopting, that you should do that and be aware of the things that you should put down. We also talked about this concept of having some decision tree of deciding, you know, where levels of conflicts of interest. So I think you want to do that, and as we talked about, you want to review everything that the firm has done, all the quids and the quos, anything that the firm has done to incentivize parties, whether they be internal or external or affiliated, to you know, to bring in business. And take a look at those very closely to see if they are implicated by the rule. And then training is very important, because, you know, as I always tell my people from day one that it's kind of corny, but I always say, you know, every Marine carries a rifle. And maybe the exact phrase is every Marine is a rifleman, but the point is, no matter what your job is, you're a compliance officer. And everybody, we're all in the same boat. And so if as a compliance officer, we're in charge with administering the program, but we can't possibly check everything that happens. And so the training is very important for everybody that falls into your jurisdiction, to understand that you know, every Marine carries a rifle. Everybody's a compliance officer, because it only takes the weakest link, right? So it's important for that training to go through, because, again, there's going to be a lot of activity under the marketing rule and the solicitation rule that you just have no control over. So to the extent business people that are on the front line understand the basic principles, that goes a long way. So I think the training is really key.
Yeah, I'll do this real quick. I look at this as much as next steps as some things you just have to remember. So don't be afraid to take baby steps. That being said, you can't take baby steps with regard to the rule itself. So you can't go back and put the use of testimonials into your policies and procedures and then not get in line with the performance advertising issues. So remember, it's kind of an all or nothing thing there, but you can take baby steps. Remember, this needs to get done at the firm level. So if any of you are reps, you can't say, I just learned how to utilize testimonials, and you go ahead and you update your pages. This is still done at a firm level based upon the firm's policies and procedures and that supervision. And I didn't leave you any time, Mark, but you got time.
I'll try to be succinct. Woe is not us, all is not lost. Do not abandon hope, all ye who enter here. There are 100 ways to skin this cat, and you've done it before. You've got the tools to do it. I know we've been a little negative about the challenges presented by the rule, but I think the way it's going to translate is a lot of work ahead of us. But you know how to do it, and I'm confident you've got the tools to be compliant when November comes around. Thank you.
I'm inspired by that, so thank you very much, Mark Perlow, Dan Bernstein, Gordon Eng, for a great discussion. Thank you all.